Welcome to Ashmont University. I'm your professor today, Adam Ashba, and today we're going to be discussing the Columbus Board of Realtors purchase contract. We'll be going through this in great detail with attorney Emily Owens. She is an attorney with Search to Close Title Company located in Columbus, Ohio. She does a fantastic job going in great detail the purchase contract, and we'll be covering it right after this.
That contract there. All right. So, a couple of kind of introductory things as you go, especially in this first section, be careful to insert all of the parcel numbers and double check those parcel numbers for the premises when you are writing up an offer. Most homes, not all, but if they're in a subdivision, they only have one parcel number. Condominiums, they sometimes have two. Sometimes you're going to have one parcel number for the unit and another for the garage. And rural properties can have several parcel numbers. It just depends. So double check that information, because I have seen, especially in the condo situation, where a garage parcel is left off. And I've seen it on the side of, like when we're doing the title search and I look back in the chain of title, and I would assume it was left off of the prior, maybe the prior purchase contract when the property was sold or purchased previously, and the unit is in the name of the seller, but the garage is in like a prior owner's name because it was never transferred. We'll double check the deed. The deed has the legal description for the garage, but they missed the parcel number, and the auditor shows that like someone else owns it. And it can just be not somewhat complicated to fix, but it's just important to note and to double check when you're preparing a purchase contract. Obviously, a lot of that information is on the MLS, or it's available, in the county auditor's site. And if you need help, there's something maybe complicated, you're not quite sure about the parcel number, or is there more than one, you can always reach out to us to help in that scenario. So the question is, would title insurance cover if that garage were left off the condo? I think it could, Kyle, and that's a good question, but there would have to be some sort of loss suffered. So, and I'm trying to figure out what that loss might be. But if for some, if the garage were left off and that property was transferred, and then there's some sort of loss to the seller, they could make a title claim there. It just would, I'm trying to think of a scenario where you might suffer some sort of loss because of that. But if there is, yes, it could be a title claim, and you could have an issue there for sure. All right, purchase price. I mean, I think that's, pretty obvious. I don't know what you guys can see on the screen right now, if it's still the contract or not. I was trying to show both, but I don't think it'll let me do that. So additional terms and conditions, this is a section where we, okay, thanks. It's a blank contract. Okay. I just wasn't sure if you could also see the PowerPoint, but if you're in a scenario where you're writing additional terms and conditions, use, if you can, the standard clauses that are put together by the board. And if you're getting into maybe an escalation clause or even gap appraisal language, use a separate addendum page. It's just always wise, instead of trying to kind of fit it in this section here, use a separate addendum page to set out those additional terms and conditions, and have the buyer and the seller sign the contract and the addendum. And if you can, use the clauses provided by the board, quite honestly, because it protects you. So you'll see, you know, I think most people have these, or they're available, you know, on your dot loop through your brokerage, but they have different standard clauses in terms of home contingencies, backup offers, assumptions, closing costs paid by seller, all of those types of things that might be common when you're drafting additional terms and conditions are available if needed, kind of as you go. Or reach out to an attorney you trust or a title company. You can reach out to us and we can help draft those. All right, the attorney approval clause. So I always hear, and I think there's a misconception a little bit, that the attorney approval clause is just like a way for someone to get out of the purchase contract. If an attorney reviews it and says, oh, we don't like it, it allows us to, either the seller or the buyer, to terminate the purchase contract. But that's not necessarily the case. So if you look at the language, it says the buyer or seller may terminate if the party's attorney disapproves this contract by providing written notice of said disapproval. So that's what they have to do. They have to provide written notice of the disapproval, along with changes proposed by that party's attorney to remedy the disapproval. So it's not just, hey, we don't agree to this. It has to also come with changes proposed by that party's attorney. And maybe that is the purchase price, or something to do with the inspection and remedy time frame, or something with appraisal language, or, you know, something like that. That's fine, but they have to propose changes within, you know, however many calendar days you insert. If you leave that blank, this clause is not applicable to the purchase contract. So the other party has the option to accept the changes in writing within 3 calendar days after delivery. And if the other party accepts those changes and says, hey, yeah, we're fine, your attorney disapproves of the purchase price, we're willing to adjust that, they have to accept those proposed changes in writing, and the contract continues in full force and effect as amended by whatever changes or have been agreed to. The party requesting the changes can waive that request prior to that expiration of the 3-day calendar period. If the contract is terminated based on Section 2, earnest monies returned to the buyer. So this is one of those Sections 2 where you're not bound by, like, so say you put in 5 calendar days in that blank spot. So the buyer's attorney has 5 calendar days to make changes or provide notice of whatever they disapprove of. Maybe they get that back to the seller or the buyer within 2 calendar days. Then there's 3 calendar days after delivery of whatever those requested changes are for them to come to an agreement. You don't have to take the full, you know, if you insert 5 calendar days, you don't have to take that full 5 days if the attorney, you know, is working on the weekends and gets that information to you ahead of time. So it's not similar to the inspection and remedy section when it comes to how the time tolls under Section 2. Okay, here. Yeah, and I can send out the additional clauses if needed too. So question is, if a buyer writes an offer with appraisal gap language, says in the event Appraisal comes back lower than the contract price. Buyer will pay $15,000 more than the appraised value, not to exceed contract price. Okay, and the appraisal does come in $15,000 under. Can the seller refuse to honor the agreed upon contract term? If that's what the language, you know, and they've accepted an offer with that language that says that they'll pay $15,000 more, not to exceed the contract price. And I don't believe the seller is in a position to refuse to honor that term. Okay, so, and this is where, and we can talk about it now, where it depends on who you are representing when you're talking about appraisal gap language. Because what I have seen often is most of the time sellers want to have a floor or a guaranteed spend where, you know, the buyer might say, hey, we're willing to pay $15,000 more than the appraised value, but the seller doesn't want a situation where the appraisal comes in $30,000 lower and then they're stuck, you know, agreeing to a purchase price that they didn't really contemplate or they might not think is fair. So for ways to protect the seller, you know, what you want really is a counter offer that sets the purchase price, or at least sets a floor for what that purchase price is going to be. So, you know, the Bar Association or the board has an appraisal clause that says, should the property appraise for less than the final agreed upon purchase price, buyer will cover any shortage of appraisal up to a maximum of blank dollars. What's important in that scenario is to put final purchase price shall be agreed to in writing by buyer and seller. So you can add language that says like, hey, the final purchase price has to be agreed to in writing by the buyer and seller. If you have language like that, it might allow your seller to refuse to honor that gap language if it comes in super slow. The other option is asking for a guaranteed spend from the buyer. So saying something like, buyer will pay an additional amount of $15,000, which shall be applied in the following order. First, any difference between the appraised value and the purchase price not to exceed X amount of dollars. Then you can say, second, the balance of this amount of dollars, if any, is left, applied towards seller closing costs. And then third, the balance, if any, applied as a seller credit. So that allows for basically the buyer to spend a certain amount of money if the appraisal comes in super low, and you can kind of use those funds for different scenarios. So another question, if no attorney is used, is it important to insert NA in that blank line? I mean, I like to put not applicable instead of leaving blanks, although it's not going to legally matter too much if you leave it blank, because there is a caveat written in there already that it's not applicable if there's nothing inserted. I would say most buyers do probably, I don't think most buyers or sellers necessarily use Section 2. The main purpose of it could be things like, you know, they might want an attorney to review, and we'll look when we get to Section 6, different things in the condo declarations or provisions for the homeowners association, or maybe some title commitment issues or things like that. It might allow the attorney to review those things, and if they're not satisfactory, then the buyer's able to terminate. a buyer attorney might review, I'm trying to think what else might be common for them to review. Issues with taxes, or maybe it's agricultural use and there's a CAUV recoupment, those types of things. It could be a myriad of issues. I would say probably, I mean, in contracts that I review just on the search to close side, it's not filled in most of the time. People are not using that, that section there, so. And yeah, I wouldn't, I will put together scenarios, and I can put them in writing and provide them to you guys, because I know it's hard to understand and show necessarily as we go here. Let me see if I can pull it up, because I do have a document. Let me see, and I can kind of show you that guaranteed spend language, and I'm happy to email that out to you guys too, but I think I might have it. Drafting tips, here we go. Hold on just a second here. I'm gonna stop share and then share this screen here. So this is what I was talking about as it relates to a guaranteed spend and appraisal gap language. So appraisal clause from the board states, should the property appraised for less than the final agreed upon purchase price, a short appraisal, or that's what they call it, a short appraisal, buyer will cover any shortage of appraisal up to a maximum of X amount of dollars, whatever that might be. This is the part that I think is important, which is why I had italicized it. Final purchase price shall be agreed to in writing by buyer and seller. This is also, when you're talking about escalation clauses, something important to note. So you want the buyer and seller to agree to that final purchase price. It should be, once, you know, maybe there is a short appraisal and they have agreed the buyer is going to cover that shortage up to a max of $10,000. Everyone that happens, they're covering that $10,000. What is really important for clarity, for contract's sake, is once that's agreed to, have an addendum drafted that says final purchase price is X amount of dollars. That way you're avoiding potentially a discrepancy in what the buyer thinks and I've seen this happen before. It just happened not long ago here. It was more in relation to an escalation clause as opposed to an appraisal, but still important to enter and have an addendum drafted that sets out what that final purchase price is if you're using clauses like this. So if you're looking to establish the purchase price, again, it depends sometimes on who you're representing. So if you're representing the buyer, you might write your appraisal gap clause or addendum saying that this provision shall determine the purchase price and shall supersede and control over any conflicting terms in 3.2D. And we'll get to what 3.2D is, but that's the appraisal contingency section of the purchase contract. So including language like that will help establish what the purchase price is and will lessen the chance for discrepancies between the parties as it relates, you know, once these appraisals come back in and you're trying to determine, you know, how this language works in conjunction with what the purchase price and what the offer is. But having it, the provision and the appraisal language determine the purchase price, or including language that states that, kind of protects your buyers in these types of scenarios. And then when you're representing a seller, you know, think about countering. If you get that appraisal gap language in an offer, think about countering to establish a floor purchase price. That's what I hear from sellers most often, is they're afraid the appraisal is going to come in way low And then the $15,000 offer to cover that gap isn't going to get them where they want to be in terms of a purchase price. So if you're receiving these, appraisal gap offers or offers to cover the appraisal gap, it's worth noting that it might be a good idea to counter that you're going to have a floor purchase price. Like the purchase price will be this no matter what, and the buyers might agree to that. So that will protect your seller a little bit from getting some really low appraisal and then be forced to sell for less than what they want. And then this guaranteed spend language was what I was talking about in terms of how to kind of use and make sure. Maybe the buyer says, hey, I'm gonna cover, $15,000 over the purchase price or whatever it might be. So buyer offers a purchase price of, I don't know what it might be, $250,000. In the additional terms section, you have something that says, buyer will pay an additional amount of $20,000, which shall be applied in the following order. And you can use it to cover that appraisal gap if there might be one. Again, you should add that language that provision then is going to determine the purchase price. Then use the balance of the $20,000 that it could be applied towards seller closing costs, so title company fees, commissions, whatever it might be, and then applied as a seller. Third, if there's any left, applied as a seller credit. So it's an option, when you're writing those offers as a way to say, hey, we're willing to come up $20,000, and here's how it will be spent so that the seller has that guaranteed spend. And I'm happy to, and we can talk about this, there's other waivers and things here, but I will send this out to you guys with the certificates. So. All right, so before we get into the financing section, it's 11:13. Let's take about 15 minutes. We will take a little break. You guys can get water, coffee, stretch your legs, and then we'll come and get back into the contract. So I'll put it in the chat, but we will be back at 11:28, give or take. So I guess before we move on to kind of section 3 or the financing section, I did want to go over, since we have kind of been talking a little bit about the additional terms and conditions portion and different standard clauses and that type of thing. I'll go over just briefly some of the other common ones. I mean, I think we've touched on appraisal gap language and a little bit on escalation clauses. In terms of the escalation clause language, what the board has in their standard clauses for the escalation clause, I think is great. And I would definitely go there first. And I think you'll find that it works really well for most scenarios. Another one that I'm seeing often, especially right now, is kind of seller possession after closing. So sellers are staying at the property for longer than I think customary or traditional right now. Usually because they're waiting, for their closing or a build in some cases and that type of thing. So the seller possession after closing, my recommendation, if you have, let me share this drafting tips again. If you have that type of scenario, what you really should do, and the board has a standard clause, I think that
I know.
I'm gonna mute everyone really quick so you guys can hear. Okay. All right, so seller possession after closing. Where are we here? Occupancy after closing. So what the board recommends is that you put really attached seller's occupancy after closing addendum to be an integral part of this offer. And my recommendation, you can use that addendum that's provided by the board. Your brokerage might have something as well. I also have kind of a standard short-term lease, but I think that it's really important that if you do have any extended seller occupancy after closing, that you are using some sort of short-term lease, something like that. Now, that does not mean that the seller has to pay rent while they're in possession of the premises after closing, although that can be a negotiation, and maybe they decide, and the buyers and sellers decide that that is how they're going to move forward. But what a short-term lease really does, and I think the most important part of it, is that it sets out liability. So what happens, you don't want to think of these worst case scenarios, but what happens if the property, there's a fire there, or the property's damaged in some way before the buyers take possession? Who's responsible for that? What if the seller's personal belongings are damaged due to flooding or something that happens at the property? Because you might have the buyer's homeowner's insurance covering, a fire or flood or something like that, but what about the seller's possessions? Setting out those liability issues in a short-term lease is really just going to protect everyone in the event of a, kind of worst case scenario. So it doesn't mean they have to pay rent, but, sellers should at least, strongly consider carrying a renter's policy on their belongings while they, are in possession of the property after closing, those types of things. So keep that in mind if you're working with sellers who are staying at the property after closing, because I think it protects everyone. You don't want to think about those issues, and but they can happen. So let me see, escalation addendums in here too. So again, it's important to be really clear when you're using an escalation addendum in a purchase contract. You really need to set out what that final purchase price is going to be, how high the buyers are willing to come up, how the seller can provide proof that they have a third-party offer, that would trigger that escalation addendum. The important thing to note in number 4 is, seller shall attach to the counteroffer all pages relevant to the purchase price and the signature page of any third-party offer. So it doesn't mean that you have to submit the entire, offer to the buyer, to the first buyer, but pages relevant. So maybe the first page that shows the purchase price and what their any additional terms and conditions might be, and then the signature page. And, if you can, black out any identifying information and that type of thing. So you really want to be clear in the escalation addendum how the purchase price is being determined, and entering into an addendum at the end of this, if the escalation clause is triggered, that sets out what that final purchase price is so that it is clear. Because I have seen scenarios where it's not clear and the buyers thought that the purchase price was $210 and the sellers thought it was $220 based on an unclear escalation clause and an unclear addendum. And they ended up getting attorneys involved, and it, became quite costly for everyone involved to figure out what the actual purchase price was. So, and then I am not seeing this all that often, but every once in a while, and it might be something that you're buyers talking about and having questions about, what about a non-refundable deposit? Maybe they want to, make their offer more attractive by offering a deposit that, not really an earnest money deposit, although it could be considered and applied to the final purchase price or the buyer's final cash to close similarly, but in most other scenarios, it would not be refundable. So that's an option. And if you are using or thinking about using that, there is language. You want to think, though, again, of those worst case scenarios. Is it still non-refundable if the what they call acts of God, the house is, destroyed in a tornado or a fire? Is the buyer still not allowed to obtain a refund on that deposit then? Those types of things. So, or what about if the seller terminates or breaches the contract? So it's an option, but again, you want to make sure you're thinking about all the what ifs in that scenario there. Okay, let's go back to purchase contract. All right, so financing, I think the financing section, at least section 3.1 is pretty self-explanatory. This is if your buyer is paying cash, they need to initial section 3.1 and also provide evidence that whatever might be satisfactory to the seller, that they have the funds available to complete the transaction. I had a question from an agent, and I've seen this a lot too. Again, to get that house in this market, you have buyers who are paying cash. Often I'm seeing that parents are providing the cash for close, and then the buyers are turning around after they purchase and get the property and refinancing to pay the parent or the family member back. And the question I got from an agent was like, well, how long can you even hold a title policy open so that, when the parents go to maybe sell back to their kids or they have to do a refinance, they don't have to purchase another title policy in that scenario. I would say most title companies are able to, if you're going to turn around and sell back to your kids in the next 60 days, hold what's called hold the policy open, so you don't have to purchase another owner's policy for that transaction. And she was wondering, if there was a way to include that in an additional term and condition, that, the buyer's paying cash under 3.1 of the contract, but it's contingent upon, the title company being able to hold the policy open for a later period. And I think that's fine if you would want to include language like that, not absolutely necessary, because it is more of a title company function as opposed to like a seller obligation or buyer obligation as it relates to the purchase contract. But I just got that question yesterday, so I wanted to share it in terms of cash purchases. All right, so, and we'll get to 3.2, but 3.2 is, the financing section. So you're initialing 3.1 if you're paying cash. 3.2 is the financing section. Note, if you have a cash buyer who maybe wants to get an appraisal to make sure that they're paying a fair market value or something like that for the property, not super common, but technically 3.2D does not apply if you have initialed section 3.1. So if you have a cash buyer who would like to avail themselves of the opportunity to purchase an appraisal and use 3.2, you need to include that or reference that in an additional term and condition, because it doesn't automatically apply because 3.2 relates to a financed transaction. So just know that. And, 3.1, again, the buyer has to provide evidence that they have the cash to purchase. If they don't, and they don't provide that evidence within the specified period of time, and this is similar for a lender finance transaction, 3.3 is kind of the cure or what's available to the seller if the information requested or required under the purchase contract has not been provided. So lender pre-qualification, I mean, most of the time it's probably delivered with the offer. If not, you can enter the amount of days, or if it's blank, it's going to be 2 before that the buyer has to submit that pre-qualification. Now, 3.2b relates to the loan application. So again, you can enter in the amount of days. If it's blank, the contract assumes it's 7 calendar days. And, we've talked a lot, you hear and you see on this contract calendar days. It is the term of time measurement that's used kind of throughout this purchase contract. So if there's ever any reference to days, it is calendar day. Or if your addendum doesn't specify calendar, it just says 3 days. It kind of applies to any reference of days in the purchase contract. So it is calendar days. That's the time measurement as it relates to this contract. The first calendar day, just know, is the day after acceptance. So if the contract was accepted on January 1st of 2021, a buyer's notice of an attorney disapproval must be delivered to the seller on or before January 6th, that 5-day time period, if that's, what you put in there. So just know it's the day after acceptance. Yeah, so Monica's question was, on a cash offer doing an appraisal, can you use 3.2D? Absolutely, but you need to make sure that you say in the additional terms and conditions that 3.2D applies, to this cash purchase or to this offer, because if you don't specify it technically will not apply, because 3.2 is all about the lender and all about financing. And so if you're a cash offer, you're under 3.1, and you need to specifically state that 3.2D applies to the terms or to the offer. All right, and then, part under 3.2B, making a formal loan application. 4A, you have to write in the type of loan that is being, applied for. So it's important, some people don't realize this, but it is important, for the seller and the buyer to agree on the type of loan that the buyer wants to use to finance the purchase. Obviously, because FHA, VA, USDA loans, they place certain constraints on parties and financial liabilities on the seller that vary, from time to time. So say the buyer in their initial offer says that they're making a formal application for a conventional loan. And then they start through the process and realize that they cannot get approved for a conventional loan, or it's just not going to work out for this purchase, and they need to, change and switch to an FHA loan. That is a material change to the contract and would need to be agreed to by the buyer or seller. So changing from a conventional loan to a VA loan, or changing from a conventional loan to an FHA loan, it changes the obligations of the seller. And it could be grounds for the seller to terminate. And if not disclosed, maybe initiate legal proceedings or actions against the purchaser. So that's considered a material change to the contract. If you moved from conventional FHA or VA, you would need to get the approval and agreement of the seller, essentially in an addendum that they would sign and agree to. All right. We talked a little bit about appraisal contingency, but if a property is appraised or otherwise valued for loan purposes for less than the purchase price stated herein, the buyer shall have the right to terminate this contract by written notice to the seller or seller's broker delivered within 5 calendar days after the buyer receives a copy of the appraisal or other documentation evidencing the lender's determination of value. The notice shall be signed by the buyer and accompanied with the appraisal or documentation evidencing the lender's determination of value. So the buyer is required, if they're trying to avail themselves of 3.2, they have 5 calendar days after they receive a copy of the appraisal saying, hey, we're not moving forward. Or we'd like to reduce the purchase price or come to some sort of negotiation. So if the buyer receives a low appraisal, that time period lapses and they don't deliver written notice to the seller, they've waived their rights to terminate under 3.2D. So just know that. They've waived that opportunity to waive under 3.2D if they do not provide that notice. And I skipped it, but I do want to get back to, it's section 3.2B2. This is really like the good faith, and it sets out what the obligations are of the buyer in this section and in the financing section. So the buyer shall provide information and documentation and otherwise comply with all reasonable requests made by the lender and title insurance agent during the loan application and approval process. If at any time the lender notifies the buyer in writing that it will not be able to provide financing upon the terms and conditions stated in the loan application, the buyer may terminate this contract by delivering a copy of the lender's written notification to the seller or seller's broker within 3 calendar days following the buyer's receipt thereof. So part of a buyer's good faith obligation under the purchase contract is to comply, work with their lender, provide documentation that's being requested so that the process keeps moving. If they need to, provide documentation to the title agent in order to keep the process moving. If for some reason the buyer's notified that the lender can't provide them a loan, based on their initial application, they have 3 calendar days to notify the seller in writing of that. If they don't, and they miss that time frame, then they kind of waive, you can see it in bold there, the failure of the buyer to deliver the lender's written notification within 3 calendar days following buyer's receipt constitutes a waiver of the buyer's right to terminate the contract due to failure to obtain financing. So they technically would not be able to terminate based on not being able to get financing if they don't provide that information to the seller. And then 3.3 I touched on, but it's really the remedies available to the seller if they are requesting financing evidence and the buyer is not providing it. So maybe they haven't received evidence of a pre-approval or evidence of a loan application, or a loan commitment, those types of things. The seller has at any time until 7 calendar days before the closing date, notify the buyer in writing that the seller has not received whatever they're looking for. So maybe it's, you're a cash buyer and you haven't provided some information sufficient for the seller that shows that you have the funds to purchase the property in cash. Whatever it might be, they have the ability to request that financing evidence and issue kind of a written demand for that. Then the buyer has 3 calendar days after the seller has said, hey, I need to see your, loan pre-approval or your evidence of a loan application, whatever it might be, to provide that. If they don't, anytime until the financing evidence has been received, the seller can terminate the contract. So if they're requesting information and the buyer's not providing it, this allows the seller to terminate the contract. And you want to look at 3.3 to see if that's an option for your seller if they are looking to try and terminate. The thing to note here, though, is that if a seller terminates and references 3.3, and a lack of financing evidence or something like that, it is, you can see it's the seller's sole legal remedy for the buyer's failure to deliver the financing evidence, and it acts as a bar to any additional legal or equitable claims that the seller may have against the buyer. And it also constitutes the seller's consent to release the earnest money. So if there's other issues and the seller wants to have the option maybe to initiate a legal action against the buyer for breach of contract for something, do not use 3.3 to terminate the purchase contract on behalf of your seller, because this is their only legal remedy. They can terminate the contract, but it is a bar to additional legal claims that they may have against the buyer. So make sure that there's nothing else out there, if it's a very contentious contract or a breach where the seller wants to retain the earnest money or, whatever it might be, 3.3 is not the avenue to use. So I just want to point that out. It's their sole remedy if they're terminating under 3.3. Questions about that one? And then section 4, taxes and assessments. I think the one, what's the seller required to pay at closing? Any delinquent taxes, any assessments that are a lien as of the date of the contract. C gets missed sometimes or not understood sometimes, but it's agricultural use tax recoupments for the years prior to closing. So if this is a property that's used for agricultural purposes and participates in the what's called the CAUV program, when the seller sells, if you're just using the standard language of section 4 in the purchase contract, the seller would be required to pay any recoupments for the years prior to closing. And that's information that you would get from the county, but depending on the size of the property, it could be several $1,000s that the seller would be paying to the buyer at closing. And I've seen it where the sellers don't realize this. Obviously, this can be addressed in an addendum that changes that term. But if you don't have any addendum, the title company is going to find out what those tax recoupments are, and that's a cost to the seller on the settlement statement, and it can be quite costly. So if you're using, agricultural land or selling agricultural land, figure that out, or it's a good idea to talk with your seller ahead of time to figure out if something needs to be paid to the buyer. and on the settlement statement, or if you need to submit a counter that says the seller is not going to, pay tax recoupments, CAUV recoupments, things like that. So, and then E is the tax proration. So, what the seller is required to pay is a tax proration through the date of closing based on a 365-day year. It is based, on the most recent available tax rates, assessments, and valuations as reflected in the current tax duplicate. So, again, this might not be a one-to-one credit for the buyer. If taxes increase after closing, and that information is not available, the title company is using, the most recent tax duplicate, then your buyer's not going to get maybe a full credit for those taxes at closing. And it's just important to note that, because we'll get questions every once in a while from a buyer after closing that says, hey, we got the tax bill, doesn't match up to the proration on the settlement statement. And that is a definite possibility, especially if taxes go up. Any questions on that one? In regards to 4.2, if you're wondering if there's a community development charge and if this section is applicable, that information typically is available through the county auditor. Just a word of warning, occasionally you've seen some of these types of community development charges misindexed, and so there is a possibility. I haven't personally come across this where there has been one, but it's not been shown as a county auditor. But if you have questions, work with us, reach out to the title company or a real estate attorney who can do kind of a double check and make sure that, there aren't any, or it's reflected correctly on the auditor's website. And then in 4.3, this is where the seller needs to disclose if they know of, future assessments that might be coming. So we had an issue I've seen a couple times where the community put in sidewalks. And so this is while the seller still lived there. They sold the property. In the agreement to construct the sidewalks, they, neighbors and the community agreed that there would be an assessment. It could be paid up front by the property owners or assessed on the property taxes. And then they did not disclose that to the buyer. So the buyer, after they purchased, got a letter from the county that said, hey, you can pay $8,000 now for these sidewalks, or it'll be assessed on your property taxes. So know that if your seller has knowledge of something like that, under the purchase contract, they're required to disclose that information. If they don't, it could be an issue of fraud, where if they, knowingly withheld information or knew something like that, you could have a claim for fraud. The other thing to note too is if the seller discloses, hey, there's a future sidewalk assessment or something like that, it doesn't specifically say, 4.3 doesn't say like the seller has to pay it. That can be a point of negotiation between the buyer and the seller. The seller's responsibility under the contract is to disclose it. So just make sure if it's disclosed on the property disclosure form or somewhere, it just needs to be disclosed, not necessarily paid for, although you might have those negotiations as well. All right. Section 5, fixtures and equipment. A couple years ago, they bulleted out these, I don't know if you remember, it used to just be like one giant run-on paragraph, but it's kind of nice now. I think you can see really well, what they consider to be fixtures, unless they're excluded specifically in the purchase contract. My only really note on Section 5 of the purchase contract is just be as specific as possible. If your buyers think, or your sellers think that something should go, where I see issues come in is usually it's after closing. The sellers thought that the drapes or curtains were not a fixture. The buyers thought that they were staying, and the buyers go to move in and they're gone, and there's a discrepancy over, was this a fixture? Should it have stayed? If there's anything, out of the ordinary, or it might be open for interpretation, use as specific language as possible. So you can see here, the contract already states curtain rods and window coverings, excluding drapes and curtains as a fixture. But again, you want to be as clear as possible. If maybe the buyer's requesting drapes and curtains to be left at the property, you need to include that. And don't use general language. I saw one time in that scenario where they just wrote window treatments. Well, the seller thought that window treatments meant the rods and window coverings, and the buyer thought that window treatments meant drapes and curtains. So, avoiding that language like that, I think is important, and it hopefully will help avoid these issues down the road. And, a lot of times lenders, if there's a lender involved, they don't want to see a bunch of different, items, I guess, or personal belongings or things like that. If you do have a buyer who might be purchasing furniture or entertainment equipment or whatever it might be, the best option is probably a separate bill of sale, and do not include it in the purchase contract. Because really, this is a sale for real property, personal belongings, and TVs, things like that. If a buyer's purchasing them, should be dealt with in a separate bill of sale that can be incorporated or referenced in the purchase contract, but it can be, it should be separate. So, and in terms of, it's hard in Ohio to get a lot of legal clarity on fixtures and equipment in the residential sector, mainly because you don't have a lot of cases where courts had to determine whether or not a refrigerator is a fixture, whether it was someone's personal property, mainly because the value of these items that are taken or left at the property are of such, not so low, but it doesn't rise to level of going through the cost of a lawsuit to have a court determine it. And honestly, what happens most often is you as the agent kind of foot the bill or try to do something to make everyone happy. So you don't have a lot of clarity from courts as to what they consider a fixture. So these things can be open for interpretation. Yeah, and built-in appliances, and it's included here already in the bulleted list that it would be a fixture. And I think most courts would think that, but again, you'll have other issues that it's just somewhat unclear, or the seller wants to take something and you'll see in that fourth bullet point down, attached media brackets. So not the television, but the bracket that's attached to the wall is considered a fixture. You might have a seller who wants to take that bracket off and take it with them, which is fine. But unless you specifically exclude that, you might be in a situation where the seller's taken something they thought they could take, and then find out that the buyer thought it was going to stay. So, all right. Everyone's favorite section, inspections and tests. So in this section, I guess I will say at the outset, if you have, you know, especially right now, buyers who say, hey, we're not going to do inspections. We're purchasing as is. It's a way to make our offer more attractive, that type of thing. That is fine. But for your own liability, I think it's important to have something, yeah, see, porch swing. You know, it's one of those things. Buyers have certain ideas and sellers have different ideas. And, you know, in that case, you'll have, you know, in that case, it's kind of nice that they found out prior to signing paperwork, because I've seen it where it's after the closing, everything's signed, and they go to move in and that front porch swing is gone. And what are they? They're calling you and the title company and that type of thing. So, all right. So if you have a buyer who's looking to waive maybe their rights under Section 6, to protect yourself from liability, I think, and I will, let me share this. Hold on just a second. It doesn't have to be anything super formal or specific, but you want to document that waiver somehow in your records and in your files. So you can see an example that you could use. It's recommended that legal advice be obtained prior to waiving or releasing contract contingencies. This document that client and so this is something that you and your client sign, not necessarily part of the purchase contract, but, you know, think about it in relation to Section 6. This is to document that client and agent discussed client's rights under paragraph 6 of the real estate purchase contract regarding the premises known as blank. Client acknowledges agent discussed their rights and client hereby waives their rights under paragraph 6 of the purchase contract. So you have that documentation, because what ends up happening is maybe the buyer decides to waive their inspection and remedy period in Section 6. And so agents are just writing, you know, Section 6 is waived and the additional terms and conditions or something like that. And the buyer purchases the property, something is very wrong, you know, with the property after they purchase, or they discover some major defects. And what do? They sue everyone involved. So they're going to sue the seller, the listing agent, the buyer's agent. And what courts are finding is that, you know, agents have no documentation, maybe that they were not giving their clients legal advice as to, you know, what their obligations or rights were under Section 6 of the purchase contract. So having some sort of documentation that says, hey, I always recommend you get an inspection, and I always recommend that you obtain legal advice before waiving this, keep that in your file, because all it's going to do is really protect you down the road if something were to happen. Buyers are knowing, if they knowingly waive something like, you know, Section 6 or something like that, you're not going to be held liable for that. Where agents get themselves into trouble is suggesting not, you know, a buyer not have an inspection, or some attorneys consider this, if you waive Section 6 and don't, you know, recommend that your client get legal counsel, that this could be the unauthorized practice of law. You know, you're opening yourself up to some liability here. So, oh, and there might be a I was told there might be a board document for waiving. And yeah, and if there, some brokerages have them too. I don't think it needs to be anything super specific, but having some sort of documentation of that waiver for your files will protect you. And Section 6.1 was changed recently that just states that there's a recommendation that inspections and tests be performed by a home inspector licensed by the state of Ohio. So this comes from kind of the change from, I think it's been about 2 years now, that, you know, that home inspector license bill that passed. So there is a requirement now that home inspectors be licensed. There is a grandfather clause in there that, you know, if you're already, I think, a home inspector, you don't necessarily have to go back and get a license, but they made some requirements for home inspectors in the last couple years. Initially, the Standard Forms Committee and maybe the board agreed that and had wanted language that said that it was required that a licensed home inspector be the one that, you know, performs the home inspection. And for the Bar Association attorneys, like, really pushed back on this one. So now you'll see it's just a strong recommendation that you use a licensed home inspector. It's not a requirement under the purchase contract. And partly that is too because the state is so behind on putting together what the qualifications are to get a license as a home inspector and the process. They're like a year behind. I don't know where they are right now on it, but the state's just not, they haven't kind of put that plan together yet. So it's recommended, it's not a requirement under the purchase contract. So 6.3 is that specified inspection period. If this is one of those sections that if it's blank, there is no inspection period. They waive the right to inspect, request remedies, or terminate the contract due to unsatisfactory conditions. And the type of tests under 6.3 are really entirely within the buyer's discretion, and you can kind of see what those are available to the buyer. But whatever you put in, and I think customarily, I don't know, you guys might know more than I do what that time period is, but it's known as the specified inspection period. It is a specific time frame agreed upon by the seller and buyer. The number of calendar days cannot be modified or waived except by written agreement. So this is one of those that when you think back to the attorney approval clause, you put in 5 days and the attorney gets their notes back and changes back within 3. Then you can waive those other 2 days and move forward. You're not stuck at that 5-day time period. This section is different. Whatever you put in there, that's the time frame. That is not waived unless it's in writing in an addendum by the buyer or seller. So it's different than other sections where you have time frames listed. And then 6.4 is, so there's 6.4a, which is agreement to remedy, or 6.4b, which is the notice of termination. So buyers technically under 6.4 have a good faith obligation when dealing and looking at inspections and inspection reports. So if they're not in good faith, satisfied with the condition of the premises as disclosed by inspections, tests, or other reports, the buyer can elect to proceed under one of the following. So they can agree to remedy, And on or before the end of the inspection period, the buyer shall deliver to the seller or the seller's broker a written request to remedy, stating the unsatisfactory conditions, along with a written copy of the inspections tests and reports. The buyer and the seller have blank calendar days, so whatever that time period is, to reach a written agreement regarding remedying the unsatisfactory conditions. And what you'll see, I think probably you guys are seeing a lot of, and we're doing a lot of right now, is where your buyers are still getting that inspection, but maybe they're waiving 6.4, the ability to remedy or terminate or request remedies from the seller based on that inspection. So they might still be getting that inspection, but then 6.4B is waived. And so if you, similarly, if you're waiving, section 6.4 under the purchase contract, I would again document that waiver for your own records between you and your client. Buyer can waive their request to remedy and proceed with the contract. The commencement of the agreement to remedy period does not obligate the seller to reach an agreement. And the delivery by the buyer of a written request to remedy any unsatisfactory conditions does not preclude the buyer from later delivering a notice of termination as contemplated by paragraph 6.4B. So just because the buyer requests a remedy does not mean they cannot terminate at a later time under 6.4B. So there's a question, if there's a problem with the inspection, a bigger problem, maybe more than $10,000 or so, but you waived remedies, what do you typically see buyers and sellers agreeing to? Adjust the purchase price, seller to pay money at closing. I guess I can't say for sure. I mean, if there's a big problem with the inspection, but you've waived, maybe you've only waived the remedies, and the seller or the buyer has the ability to terminate. I have seen that. Or I haven't seen a requirement, and maybe they agree to it just to stay in contract, that the seller paid money at closing, towards the buyer. They reduce the purchase contract or purchase price, which would be fine, but technically, if the buyers waived their ability, or the request to remedy, the seller would not be required to provide some sort of credit for maybe that $10,000 or something like that. Now they could if they didn't want to lose this buyer, but technically they wouldn't necessarily have to do that if the buyer waived their request to remedy. Kelly says there's a clause for that, so yeah. Yeah, and I think I haven't looked through the other clauses, but yeah. Yeah, so there's a remedy clause. Buyer waives the right to request that the seller remedy, repair, or offer any financial credit for any unsatisfactory conditions. The buyer still reserves the right to terminate this contract if they are not in good faith satisfied with the inspections per section 6.4B of the contract. 6.4A is hereby removed. So yeah, similarly there. And then section 6.5 is newer to the contract and the change in the last year here. And what it really does is it ties those important condo and HOA documents and brings them to the attention of the buyer in the same way a home inspection kind of informs the buyer as to the physical condition of the property. So if the premises is a condominium unit governed by a condominium association or in a community governed by an HOA, seller shall provide buyer with the following information and documents within 5 calendar days after the date of acceptance of the contract. And it just goes through that whole checklist of what the seller will provide the buyer. The buyer has then kind of a review period, almost like a remedy period, but a review period. And their obligations are contingent upon satisfactory review of the documents provided. The buyer has 5 calendar days after receipt of the last delivered document, or 10 calendar days after date of acceptance, whichever shall first occur, in which to review the documents. So the buyer has 5 calendar days after receipt of the last, or 10 calendar days after acceptance. It just depends on which happens first. So if your buyer's trying to determine how long they have to review, or where they are, if they would wanting to terminate or something, you need to kind of double check that time frame there. But in situations you might have the seller who does not have some or all of those documents, that's fine. But if the buyer is not provided some of those, or on the other hand, if they review them and are not satisfied with them, then they can deliver a notice of termination to the seller, and then the earnest money is returned to the buyer. So think about in scenarios, and I've seen it happen, where someone wanted to purchase property. There was a homeowners association involved, and they had wanted to set up a pit bull rescue in their backyard. So their plan had been to fence the backyard and then set up this dog rescue in the back. Well, they reviewed the covenants and restrictions and HOA documents and found out that you can only have 1 dog, and you're also not allowed to install a fence in the community. So, in that case, they would potentially use Section 6.5B to issue a notice of termination to the seller. So I got a question too, where do you get all of that information? What if the association doesn't respond quickly enough? And it happens, so the title company, request that type of information from the association. We can, and have done it before, do that, on your behalf so that you can provide that to the buyer. The other option is your seller, as the owner of the property, typically is in the best position and has access to that documentation. So getting it ahead of time is always a good idea. If your seller has access to the bylaws and unrecorded rules and regulations, financials, get that at the time of listing so that you can provide it, upon acceptance of the contract. If you're waiting around, or you have an association that's not responsive, which definitely happens, it doesn't say that the buyer can kind of waive their right to terminate because certain documents aren't available, or, the association isn't responding. They don't have to review everything. If they're not provided with some documentation and they're okay with that, then the contract can kind of move forward. But the easiest way is to get it, as much of that information ahead of time, and your sellers often are in the best position to request that information from the association if they can. The title company is another option to do that, and we've done that before for sellers or for agents who are maybe not listed yet, but they've signed listing paperwork and they know they're going to need that type of information, and then we can request it. Any questions on that one? And I think probably also the best practice, if you're in a situation where you can't get certain documentation, Best practice is to notify buyers as soon as possible if some or all of the requested documents don't exist or aren't available. You know, let them know ahead of time so that you can kind of move past that review period. And just a second, I have a question. Yes, the question too is, I assume you can waive that HOA section in the offer if they review ahead of time. Absolutely. You know, any of these sections technically can be waived or negotiated or adjusted as they're written, you know, right now. You know, that's what it says, that you have a certain amount of time. But yes, it could definitely be waived. I'm going to skip over 7 and 8. I mean, home warranties are pretty, oh, I do have a question. There is a question about the home warranty. So is there some sort of documentation or suggested language to provide your buyer client regarding the home warranty? For example, something to cover yourself should a mechanical break and the warranty only covers $200 or less than the replacement cost. Oh, yeah, I mean, I guess you could have some similar disclosure that says, you know, you don't, pretty much like you don't work for the home warranty company, you are not making any representations about what is covered. If they have questions about the plan, you know, that's up to the home warranty company, whoever's providing that warranty, to explain. I would probably avoid making any statements as of, you know, like, well, they always will replace this or they'll do this. You know, every company is different with what they'll cover, with any deductibles and things like that. So avoid those, you know, sweeping generalizations. I don't think a buyer, if they were trying to like hold you legally to, you know, what a home warranty covers or does not cover, would have much legal ground to stand on. So I don't think have much to be worried about as it relates to that. And then title insurance. So, you know, this is pretty much a section that allows the seller in Central Ohio, when you're using this contract, to pick the title company, because under section 9.1, the seller is the one that's going to furnish and pay for an Alta homeowner's commitment of policy of title insurance in the amount of the purchase price with a copy of the subdivision or condominium plat. So as it stands, you know, your seller is required to provide a homeowner's commitment and a homeowner's policy. That's applicable really for most residential transactions. A homeowner's policy, the Alta homeowner's policy, is the Eagle policy. It's the best policy that you can get. There are times where an Alta policy a homeowner's policy isn't applicable, and that would be more for vacant land. So a homeowner's policy cannot be issued on vacant land, and in that case, the seller would be furnishing and providing an owner's policy. So there are times where it's not, you know, for commercial purposes, a homeowner's policy is not appropriate, and you would be issuing, or the title company would be issuing, an owner's policy. So there's a kind of caveat or carve out there that says that, you know, in case it's not available, you can, the seller can pay for an owner's policy. Owner's policy, I mean, really, it's less robust and covers a little bit less than the homeowner's policy. Buyer's responsible for any coverage that requires any additional premium for endorsements or the deletion of any standard exceptions. If you have a buyer who has questions about exceptions in the title commitment or certain things that show up in the title commitment, I mean, I always recommend that you refer them and recommend that they speak to legal counsel. The interpretation, I mean, you should know probably how to read a title commitment and find those maybe red flags, but the interpretation and explanation of a title commitment is just beyond your license requirements and obligations. So, if you have a buyer who has a bunch of questions about the title commitment, refer them to an attorney who can kind of help address those. So 9.2 says that a seller shall deliver or cause to be delivered to the buyer or buyer's broker a copy of the commitment no later than 15 calendar days prior to the date of closing pursuant to this agreement. If the seller does not deliver the commitment within the stated time period, the buyer may, by delivering written notice, either terminate the contract or extend the date of closing to the 10th day following seller's delivery of the commitment. So this is also where I say that, make sure your title partners are mindful of the time frames and are providing, the commitment within the appropriate time frame to the buyer or the buyer's broker. Because I have seen it before where buyers are looking for a way to get out of a contract and they are able to use Section 9.2 because the title company did not deliver the commitment within the stated time frame. So you just want to make sure that that your title partners are mindful of that, and I think most are, but you wouldn't want someone to be able to terminate based on 9.2, for that type of reason. And then 9.3 allows the buyer to object to certain issues in the commitment if it indicates that title to all or part of the premises is unmarketable, or if the buyer in good faith objects to liens, encumbrances, easements, conditions, restrictions, all of those types of things. So the buyer has the ability to make those objections if there's something, in the title, in the commitment that makes some or all of the premises unmarketable. So that could be, maybe a survey issue where you would get the survey back and there's an encroachment. And what happens under 9.3 is that the buyer has to notify the seller and allow the seller to remedy or remove that lien or encroachment, whatever it might be. And there's different ways that a seller could remedy that. So for an encroachment, maybe the seller's option to remedy is that the seller purchases an endorsement on the title policy that covers the buyer in the case of a forced removal or something like that. Another remedy could be that the seller is going to enter into an easement with the neighbor that allows for that encroachment to kind of continue or something like that. There's lots of different ways a seller might decide to move a fence, back within the property lines or whatever it could be. So the seller has the ability to remedy those objections, but if it states there at the bottom that in the event that the cure of an objection will subject the seller to additional expense, seller shall have the option to either cure or terminate the contract. So the seller's not going to have to purchase that endorsement to cover the encroachment. They have the option to cure it by doing that, or they would be able to terminate under 9.3. But again, if you're in this section and in section 9 trying to determine objections to the policy and things like that, make sure that you're working or at least referring your client to work with an attorney who can help them, because this can get somewhat complicated, I think. And then 10, relates to utility charges and things like that. Pretty self-explanatory, although 10.4 kind of sets out who's responsible for what between the seller and the buyer when you're dealing with homeowners or condo association. So the buyer is going to pay all initial reserves or capital contributions that are charged by any owners association or civic association in connection with a sale or transfer of the premises, as well as any fees associated with lender required document costs. So what's the lender requesting? If it's something that's going towards allowing the buyer to finance the transaction, that's going to be a buyer cost on the settlement statement. Seller is going to pay fees that are charged in connection with the sale or transfer. So a transfer fee, that type of, statement fees. So the cost to pull those documents sometimes will be a seller charge, delivering those statements. That is a seller charge. The idea is too, the seller can, before listing, before selling their property, figure out what there's a better way for a seller to, or easier way, I guess, for a seller to determine what those costs will be. They can find out what a transfer fee would be, and, they have the ability to determine what the cost of obtaining those statements and things like that are, and that could be worked into, the list price or the sales price. So the seller has the ability to kind of anticipate those ahead of time, which is how they kind of set out section 10.4. And then briefly on section 11, if you ever find yourself looking at this section, see that note at the top. It's recommended that if there is damage or destruction of premises, attorneys, parties need to retain legal counsel, because there's lots of different scenarios. And, when you're talking about payment of insurance proceeds and things like that, if you find yourself looking at section 11, make sure that you're working with legal counsel and that your parties are as well. As a general matter, the risk of loss prior to closing is borne by the seller. So again, to go back to seller occupancy after closing, if it's a scenario like that, after closing, the buyer's insurance technically is going, and they would be the party that's bearing that risk of loss. So you want to have, a short-term lease or responsibilities and liabilities set out if that seller is retaining possession after closing. But I won't get in too much to 11, but the buyer has several options if the property is damaged or destroyed prior to closing. Yeah, and then this is a good question as we're getting into earnest money. What about title companies holding earnest money? The contract says buyer's broker is responsible, not the title agency. Great question. I know the Standard Forms Committee is looking at adjusting this language right now because there are so many, it's becoming so much more common for us at the title company to hold the earnest money. It's easier. Brokers don't want the liability as it relates to holding earnest money if there's a dispute or the contract terminates, that type of thing. We can more easily kind of credit it, on the settlement statement at closing, all of those types of things. So it is becoming much more common for the title company. Until the contract is changed, and I think what they're looking at making in terms of the change, instead of saying broker, it would be the word would be holder. So whoever that holder is, whether it be the broker or the title company. As it's written right now, I would reference, if the title company is holding the earnest money, I think it can just be a quick phrase or clause in the additional terms and conditions that just states, XX title company to hold earnest money on deposit until closing. Any reference to broker in section 12 of the purchase contract, shall apply to the title company. Something like that, that just ties in that the broker, if the title company is the one holding the earnest money, the broker can also mean that company for the purposes of this contract. So I think you don't have to go through and strike out every time it says broker, but a clause in the additional terms and conditions that says, any reference to broker, the holding of earnest money shall refer to the title company. Yeah, and I can send you guys, I don't have official wording on that, but I can send that to you. It would not be a problem at all. You have the option, I mentioned it at the beginning, earnest money is not required by law. You can have a contract without earnest money. It happens all the time. What I like now is that there's kind of set out in the standard contract 2 different time frames for when that earnest money is to be deposited. So within 3 calendar days after acceptance of the contract, or you can have a buyer who says, let's wait till after the expiration of the agreement to remedy period. And that one, came about honestly because obviously a lot of contracts terminate in that agreement to remedy period, and it just avoids the back and forth with the return of earnest money or things like that if it's not deposited till after you get through that section. So, earnest money is kind of regulated by Ohio law in terms of what happens if there's a dispute. So if you don't get to closing. If you look at section 12.3 of the purchase contract, that is kind of a verbatim restatement of what Ohio law says. So here's what happens, to the earnest money. If the seller fails to perform, if the buyer terminates this contract, that type of thing. If the buyer fails or refuses to perform, then the earnest money is deposited and paid to the seller. In any event, except as provided in paragraph 3.3, which we talked about before, and subject to collection by the broker's depository, all earnest money deposited is to be dispersed as follows. And that just goes through the scenarios of how earnest money is to be dispersed. Scenario A is the best case scenario. Transaction closes and the earnest money is dispersed or deposited to the buyer or to the closing or escrow agent as applied to the purchase price. So that's what you see most often happen. But what if the contract terminates? Well, then you're looking at sections B or C or even section D of that 12.3 there. So I can make this bigger, so that's easier. Sorry, it's hard to tell what it looks like for you guys. So, the parties can provide the broker written instructions that both parties have signed, specifies how the broker is to disperse the earnest money. That would be, a mutual release, something like that, that says we've released, our obligations under this contract, earnest money goes to the buyer, something like that. Or if they don't agree to it, the broker or in some cases, if it's the title company holding the earnest money, the broker is going to be required to wait till they receive a copy of a final court order. So meaning a court's going to say, hey, this earnest money goes back to this party before they can remit it. So what happens though is if there's a dispute between a buyer or seller regarding the disbursement of earnest money, and A doesn't apply because they don't get to closing, the contract's terminated, they never agreed to the disbursement, so B doesn't apply because they didn't provide written instructions to the broker or the title company. The broker's required under Ohio law to hold those funds in the trust account until they receive signed written instructions from the parties or a final court order saying how the earnest money is to be dispersed. If within 2 years from the date the earnest money was deposited, the parties haven't provided one of those two things, so there's no court order or written instructions, then either the title company or the broker is just returns that money to the buyer without notice to the seller. So the seller doesn't have the ability after 2 years to hold that up anymore. The earnest money is just returned to the buyer. If they can't find the buyer, then that earnest money becomes kind of unclaimed funds, and it has to kind of be held with the state. So there's lots of legal requirements for brokers that hold earnest money or title companies, which is why more title companies are holding it because brokers don't really want to be holding this money for a lengthy period of time and have to do the accounting and that type of thing associated with it. So. How and when is a note canceled if used as earnest money? I'm not sure. I don't know the answer to that question. I've not seen a note used as earnest money before, so I don't know if I know the answer to that one. Yeah, I haven't seen a cognitive note used as earnest money before, so I wouldn't. I think it would be similar in terms, but I don't know if Ohio law specifies that. And then, you have additional provisions, things like that. In 3.5, contract documents, you'll notice they have a specification that says that for the purposes of this provision, contract documents do not include voicemail, email, messages, or text messages. So if you're, we mentioned kind of before when we were talking about contract offers and acceptances, text messages don't apply. You can't use a text message between you and the listing agent as a contract document. It does not count. So you need to make sure you're using, the correct documentation, because a text message is not going to be a binding agreement under, this contract. 13.7 FERPTA. The note here that was, I think, recently added, buyer and seller are advised to determine whether seller is a foreign person as defined as by FERPTA as soon as possible. So FERPTA can have implications for buyers mainly, and foreign person is a, I guess, pretty detailed definition or nuanced definition under Section 1445 of the Internal Revenue Code. It's not just a non-US citizen. A foreign person, you can be a non-US citizen and not be considered a foreign person under IRS tax code. If you have a green card or some sort of presence in the United States, you might be kind of carved out from what is defined as a foreign person under Section 1445. But if the seller is a foreign person, and again, you know, if you're trying to determine this, it's a good idea either to talk to a CPA or an attorney to figure out whether or not the seller falls within this. The other thing with FIRPTA is it only applies for properties being sold that are $300,000 and greater. So if you're selling a $200,000 property, FIRPTA does not apply. But if you fall within all of the elements and to meet FIRPTA, the seller really might be required to do a withholding of the money for tax purposes at closing. Because if they don't, what's going to happen, or what could happen, is the IRS comes to the buyer after the closing and says, hey, your seller was a foreign person as defined under this section of the IRS code. You, buyer, now have to pay 15% of the amount realized by the seller. So there are implications for the buyer if the seller doesn't disclose this ahead of time. So if you're trying to figure it out, you know, talk to a CPA who can help determine whether or not the seller even applies, or work with the title company to get it dealt with, you know, well before closing, because there's lots of exceptions. There's lots of ways to avoid having to do a withholding, but you need someone who kind of knows that section. Okay, so it falls on the title agency potentially to do the withholding, not to determine whether or not the seller is a foreign person. And some title companies will say, this is not related to title. We're not going to be the intermediary that holds this 15%. Most will, but it's not necessarily a title issue or a title company responsibility. So you want to, and title companies, most I know, will do the withholding and will show it on the settlement statement and withhold it at closing to pay it the IRS, but it's not necessarily their responsibility to determine the seller's status under this section of the purchase contract. Most title companies I know, we have a form that a seller signs at closing that says that they don't fall within this section of the IRS code, and that's an option that protects the buyer down the road. So if the seller's sworn on an affidavit that they're not a foreign person as defined by FIRPTA, the buyer could use that, provide that to the IRS in the future if the IRS says, hey, you need to pay 15% on that sale realized. I don't know if there's any other really issues of note that I wanted to touch on. Let me see here. You know, as it relates to the residential property disclosure form, you know, most sellers, but not all, are required to complete a property disclosure form. Best practice really is to have the sellers fill that out. You as the agent are not really supposed to fill that out on their behalf. And there are situations where a seller might be exempt from filling out a residential property disclosure form. Sellers who inherited the property but haven't lived in it during the last year are not required to fill out an RPD. So that one comes up a lot. Court-ordered sale, so a sale by an executor of an estate, by a guardian, a trustee, or conservator. A seller might not be required to fill out a property disclosure form. How about a sale from maybe the buyer's the tenant who already lives at the property? The seller's not going to be required to fill out a property disclosure form in that one. So there are, I don't know which one, Carol, you wanted me to repeat, but sellers who inherited the property but haven't lived in it in the last year. Inherited the property but have not lived in it during the last year are not required to fill out a